Welcome to the law offices of Sabrina Li. If you have ever, as a derivative Asylee, told the truth during your green card interview, only to be accused of fraud by USCIS and receive a notice of intent to deny, this video may help you. Take a look at this I-485 approval notice. This is exactly the green card approval result our client ultimately received.
Sabrina is a certified immigration law specialist. Only 1% of attorneys in the US can earn this recognition. If you are in a similar situation, please call 213-375-8096 to schedule a consultation with us.
Years earlier, our client had entered the United States on a B1-B2 visitor visa. On the application, he listed an ordinary purpose for the trip: tourism and medical treatment. He did not write the real reason. He could not. The truth was that practicing his faith had become dangerous in his home country, and that he and his family hoped to find protection in America. That was not something he could safely disclose on a form tied to the very government he was trying to escape. After the family was granted asylum, his wife as the principal Asylee, and our client as her derivative beneficiary, he filed Form I-485 to become a lawful permanent resident. At his interview, an officer asked him plainly why he had come. He answered honestly, he had feared persecution, he had always hoped to remain here in safety, and, when asked, he acknowledged that he had not disclosed that intention when he obtained his tourist visa. The officer treated that candor as a misrepresentation. The reasoning was straightforward. Because his visa application stated tourism, while his actual intent was to live here and seek protection, USCIS concluded he had willfully misrepresented his purpose. Under INA 212A6CI, such a finding can render a person inadmissible, in practical terms, barred from a green card. On that basis, USCIS issued a notice of intent to deny, a formal warning that his application was about to be refused, with only a few weeks to respond. On paper, a notice of intent to deny is a procedural step. For this family, it threatened everything they had rebuilt. Our client was the anchor of the household. A denial would not simply close a file. It would pull the ground out from under a family that had already endured so much, jeopardizing his status, straining a household that leaned on him, and leaving him stranded between a country he could not safely return to and a system preparing to send him back. He had weeks to answer. Many applicants, and many attorneys, would have read the word fraud and concluded the case was over. We did not. The NOID itself revealed the path forward. USCIS acknowledged that a waiver existed for precisely this situation, and faulted our client for not having pursued it. For those granted asylum, the law provides a remedy under INA 209C, filed on Form I-602, that allows USCIS to waive most grounds of inadmissibility, including a misrepresentation finding under INA 212A6CI. So we filed it, not as a routine form, but as a fully developed case. We prepared a complete I-602 waiver package that conveyed everything the visa application never could: the persecution the family had fled, the asylum lawfully granted, his wife's health and her reliance on him, and the young child whose stability rested on a secure home. We documented the hardship to his family members, the favorable equities, and the conditions that made his fear of return well-founded, and we placed the entire record before the officer ahead of the deadline, giving USCIS not merely permission to approve, but every reason to. USCIS approved his green card just in days. The approval made our client a lawful permanent resident of the United States. It secured the safety the whole family had crossed an ocean to find, preserved the asylum they had already earned, kept their household intact, and opened the path to U.S. citizenship. That is what a well-built waiver delivers, not merely an approval notice, but a family's future restored to solid ground. If there is a single lesson in this case, it is this: a notice of intent to deny is not the end. Even a misrepresentation finding under INA 212A6CI, one of the most feared grounds in immigration law, can often be overcome with the right waiver, a thorough evidentiary record, and an attorney willing to tell your story in full.
If you or someone you know has been affected by a similar situation, contact the law offices of Sabrina Li at 213-375-8096 or email us at info@sabrinali.law.
Our legal team will do everything in our power to handle your case. Your American dream, our commitment.